Good afternoon, everyone. Thank you for joining us on our October installment of our ongoing Tenant Landlord webinar series. Today, we're going to be talking about some new upcoming regulations to shared meters that are going to be taking effect come 2025. So we'll let everyone kind of get started, and we'll get started here pretty quick since we've got a lot of information to get through. So I just see, I know we're running just a couple minutes behind, so I will, it looks like we've paused out. Perfect. So I'll go ahead and get us started. We're going to be joined today by two attorneys from Mid-Minnesota Legal Aid. Gary Van Winkle is a staff attorney there, and Julia Zwack is a managing attorney at Mid-Minnesota. So we'll let them introduce themselves a little bit more later on, but I wanted to get through quickly our Homeline housekeeping things. So for those of you who haven't joined us before, Homeline is a nonprofit organization that helps tenants specifically throughout the state of Minnesota. We've advised over 329,000 renters since we opened in 1992. So we offer free legal advice in 4 languages, in English, Somali, Hmong, and Spanish, as long with email options. So that's our contact information if you are a tenant and you have questions about your rights as a tenant. And then just a couple of housekeeping things that I wanted to get through real quick. So this session is being recorded, as you all probably know when you came on. It will be available on our website in a few days. That will include a PDF version of these slides. There's a lot of information contained in these slides, so it'll be a really helpful resource if you're going back through listening to parts of this. Please ask questions through the Q&A function that's going to be at the bottom of your Zoom screen. I will do my darndest to keep information in the chat about links and things like that, what statute numbers we're looking at. So I will most likely miss any questions that come through the chat because I'll be busy filling it with information for you all. So please, 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 please use the Q&A function at the bottom of your screen if you have questions that come up, and we will try and get to those at the end of our session today. We are going to be applying for 1.5 standard CLE credits. So if you don't know what that is, then you don't probably have to worry about it. But as an attorney, if you are looking for credit, we will get you that number in an email after the fact once it's been approved. All right, that is it for me. I'm going to go ahead and let Julia and Gary do their thing. And again, feel free to put your questions on the in the chat. Thank you so much. Or the
Thank
Q&A,
you.
sorry.
Thank you, Rachel. Well, like Rachel said, my name is Julia Zwack. I manage the housing team at the Minneapolis office of Mid-Minnesota Legal Aid. I've been doing landlord-tenant law since 2018 as an attorney, as well as a law student at the University of Minnesota Housing Law Clinic. So I'm really passionate about landlord-tenant as an area of law. I think it's a lot more complex than a lot of people realize, and I think this presentation will show you why, at least in one area, that is true. As Rachel said, there's a lot to cover today. We'll be talking not only about shared meters, but also sub-metering and other consumer protections that are now going to be in place for renters. So Gary, do you want to introduce yourself briefly?
All right, sure. I'm a staff attorney with Mid-Minnesota Legal Aid down in the downtown office in the housing unit. And just for whatever reason, I started with legal aid back in 1987, and I do handle eviction defense, but I've been involved and engaged in utility issues and utility law actually since 1987. So when these kind of things are on the table, so to speak, I usually have something to add, and hopefully it's helpful.
Absolutely. Gary is by far the statewide expert on this issue. And I don't say that lightly. I think he's the person who knows most about this in the state of Minnesota. So I'm mostly just the Vanna White to your Pat Sajak or whatever that would be. So I'll let Gary take the lead on the substance, but I'm going to introduce MMLA a little bit more first. So Legal Aid is a nonprofit law firm, and we offer free legal services to our most vulnerable neighbors. We provide expertise and compassion and basic legal protections so that our clients can achieve self-sufficiency and access to justice. We serve individuals in the counties listed on this map here, including the lowest income people in central Minnesota. The Minneapolis office serves primarily Hennepin County, but we also have coverage out of an office in St. Cloud and Wilmer, so kind of that central band of the state. MMLA is also home to the Minnesota Disability Law Center, which has a statewide reach. And we have a couple other statewide projects, including Project Care that connects people with healthcare, the Low Income Taxpayer Clinic, and the Youth Law Project. So this is just another summary slide of all the different service areas we cover at Legal Aid. We are both housing attorneys, but our office also serves clients in consumer protection, disability, family, immigration, and healthcare issues. And then, as I mentioned, these are our locations, as well as our offices I mentioned. We have community clinics in Minneapolis, housed at different partner agencies throughout the city. And then this is just our contact information. On Law Help MN, we update fact sheets that are good resources for individuals who are trying to help themselves without getting a lawyer. You can do an intake by visiting our website at mylegalaid.org or call us for intake at the number on the screen. All right, so jumping into the utility portion, I wanted to give some background generally about utilities in rental housing. So today we're going to talk about 3 different types of utilities, including electricity, gas, and then water and sewer. The 3 main methods that we'll be speaking about of tenant utility billing are outlined here. The first is that the landlord pays utilities for the whole building and then apportions them or divides them up among tenants. The second is that the tenant pays utilities directly for their unit, so the landlord's not involved in that transaction. And the third is that a landlord or a third-party billing agent can install sub-meters to measure utility usage and bill tenants for the usage in their unit. So apportionment and sub-metering are the primary issues that were part of this new legislation we're going to be talking about, those first and third options. One other option not listed here is that a landlord can absorb utility costs into the total rent payment. And in that case, utilities would be covered and included in rent. But that doesn't involve any of the laws we're really talking about today. And at the bottom here, I listed some common utility providers just to kind of flag in your mind, like who we're talking about when we're talking about these utility providers. For electricity, primarily it would be Xcel Energy. For gas, that would normally be CenterPoint. And then for water and sewer, those are local city governments. I know outstate Minnesota might have some other main providers, but this is referring to the Twin Cities metro area. And then I also listed some common third-party billing agents because these names might sound familiar to renters who are receiving bills from a third party. They would include Conservice, Sagility, which was formerly known as JIT, and then Utility Management Solutions. So those companies do the process that I talked about at number 3 above to measure and apportion bills for landlords. They can also assist with apportionment, I guess, under method 1. So in 2024, laws were passed to ensure greater fairness and transparency for renters in the utility billing process. The existing law up until this time has been in place since 2010, and it has unfortunately caused a lot of confusion and frustration for both renters and landlords alike. We were involved in helping with the passage of those laws, aiming at greater fairness and apportionment, but in practice, there was not enough guidelines or clarity for how utilities should actually be apportioned or divided. The laws also hadn't kept up with the practices of submetering that have now become a lot more common in rental housing. An overriding goal of the laws is to give renters who pay their landlords or a third-party billing agent the same or similar protections to those afforded to renters who pay a utility provider directly. So for example, if a tenant is paying Excel and needs to work out a payment plan, there are specific rules that Excel has to follow to make sure that the tenant has an opportunity to pay those back. They have to follow the cold weather rule and not shut off during certain seasons of the year. And there's also protections afforded by the Public Utilities Commission for those who are directly metered. And so what these laws are trying to do is to bring all tenants under kind of the same umbrella to receive the same or similar protections. So linked on the slide here, and it'll be available in the slides that you can look at later, is the session law, which outlines all of the laws we'll talk about. And most of these changes go into effect January 1st for leases entered into on or after that date. So if your lease was entered into before then, it wouldn't be until a new renewal that these potential new laws would come into play for your housing. Go ahead, Gary.
So the first subject that we're going to discuss here substantively is the new statute 504B.216, which replaces 504B.215. And as Julia just mentioned, it's effective January 2025 with a grandfather caveat. And that is an exception for term leases that extend beyond January 1st of 2025. And in that case, those leases would continue to be governed by 504B.215. The point of 504B.216 is to preserve the protections provided by 215 and to supplement them, particularly in the case of submetered and apportioned billing. And that's the point of 216. So if we could get to the next slide, I'll try to go through this, and I'll be coordinating sort of a couple outlines here, and I'm going to try to hit the significant points of this. There's a lot buried in here, however, and as we go through the definitions, I have to say it's important to sort of focus on the definitions in utility law. Utility law tends to have its own vernacular, and the definitions are important to quickly understanding what the utility law means in its details. So, for example, in the very beginning, subdivision B, directly metered tenant. So that's a term that has been kind of out there, knocked around informally, and we wanted to make it more formal. So directly metered tenant is a term that refers to a tenant who is receiving utility service directly from a provider like Xcel Energy or CenterPoint Energy, is billed by them and is the customer of the provider. A landlord is the commonly understood meaning in 504B.001. Here's another new term, non-usage charges. In setting forth detail in a bill so that a tenant can understand his or her bill relatively clearly, there is a distinction between measured or service charges, whether measured or apportioned, and what would be non-usage charges. So that could be surcharges, that could be taxes, that could be other local charges, but those are distinct from the actual utility usage charge, however that is either calculated or measured. Shared meter residential building, this is just to clarify that, you know, there are some multi-dwelling buildings where individual units are not measured, and we just call that a shared meter. There have been other terms that have been used in the past, single metered, master metered, master metered is a common term. We just think shared metered is more clear about what we're talking about. We're talking about situations where more than one unit shares the same utility meter. Submeter, important to understand, submeter is not the direct meter that's installed by for example, Xcel Energy. Sub-meter is a landlord or third-party billing agent installed meter that measures the service in an individual unit in a building where there are multiple dwellings and there may be one master meter for that building, which is to say it's a shared meter that measures the entire building. So sub-meter, just understand, sub-meter is not a directly metered service that's directly metered by the provider. Third-party billing agent is an entity who provides a service typically to a landlord, where the third-party billing agent handles the billing, to some extent, the collection work, and other administrative incidentals with regard to particularly sub-meter billing. It can also be a portion billing, but it more commonly lately has been used for sub-metering. Utility provider, it's important to distinguish between a third-party billing agent and a utility provider. Utility provider is your Xcel Energy, your CenterPoint Energy, or in the city of Minneapolis, it would be, for example, Minneapolis Water Utility Billing Department, your municipal. Utility service, natural gas, electricity, water, and sewer. So those are the definitions. They're relatively important because, like I said, it helps sort of understand the substantive provisions. If we could see the next slide, that'd be great. So this is a carry forward from 215, which is the foundation of 215, which was and is, as we speak, the apportioned billing statute, is the landlord is the bill payer and the customer of record. So you have a shared meter. The landlord is the bill payer and the customer of record with the utility provider. And the landlord is responsible for paying that bill to the utility provider and actually has to advise the utility provider that there is a shared meter arrangement in the building. Significantly, subdivision B is new. A landlord is prohibited from removing a directly metered tenant from the tenant's existing account. Now, this is bouncing back and forth because a second ago I was talking about sub-metering and apportionment. Now we're talking about direct metering again. So, but this is where this provision exists in 216, and it just prohibits a landlord from removing a tenant's name from an existing directly metered account or requesting that from the utility provider. And that's new. And then also there's the non-waiver provision. Subdivision C is a non-waiver provision that does exist in the original 504B 215. And so this is subdivision 3, sub-metering of electricity and natural gas. So let me just say this about that. I've been doing this for a long time, as you can tell, or at least you can tell I've been doing something for a long time. Really sub-metering, at least in the metro area, was relatively uncommon until about, at least in my experience as a practitioner. I wasn't hearing too much about sub-metering until about 10 years or so ago. And now sub-metering has become much more common. But sub-metering really is, in the Twin Cities area, is really about electricity. It's not so much natural gas. I haven't seen sub-metering of natural gas. I don't know if sub-metering of natural gas is more common outstate. It's not common in the Twin Cities. So when it comes to sub-metering in the Twin Cities, just keep in mind, we're generally talking about electricity. And if you do have sub-metering of electricity or natural gas, it has to comply with the consumer protection provisions of 216B 022 and 216B 023, which Julia will discuss later. So subdivision 4 has to do with sub-metering of water, which again is not common in the Twin Cities area. I'm not aware of submetering of water. It may be that water is submetered in manufactured home parks, but it's not generally submetered in multi-dwelling buildings in the Twin Cities area. So subdivision for C has to do with accuracy and has to do with the frequency of billing. The point of accuracy and frequency of billing is that the meters must be accurate. They must be verified as accurate, tested periodically. Again, sections 022 and 023 regarding these particular provisions will be discussed later. But for right now, just keep in mind that the billing frequency for a sub-meter has to be the same as it is by the utility provider. And the reason for that is that, particularly in the case of low-income tenancies, if the billing for sub-metered usage is not the same, so to speak, in terms of the billing interval as is done by the provider. In other words, if a billing is delayed or if the billing periods vary, it's very easy for a tenant to find themselves in a situation where a bill has gotten too large and presents a hardship in terms of payment. So it's important, and that's what subdivision B refers to. It's important that the billing frequency be the same as that of the utility provider. Yes, so subdivision B or subdivision D just makes it clear that when it comes to sub-metering, and I realize now we're talking about sub-metering of water in this subdivision, but this applies to sub-metering generally, is that there is no capital recoupment or other expense recoupment allowed from the tenant for those metering facilities that are provided by the landlord or the third-party billing agent. And the goal here is to provide the same consumer protections that were provided to directly metered tenants. Let's go to the next slide if we can. So this is apportionment, and this is important at the very top. Apportionment of electricity is prohibited. This is a change in the law, and it's a significant change. There's a backstory to this that I won't go too far into, but basically the state of Minnesota has policy that's reflected in their building code that buildings since about 1980 are supposed to be wired separately for electricity. And so for years, as I said, there was no commonplace sub-metering, but now sub-metering is becoming more common. And the measurement of electricity service, particularly, is what we're talking about here, is a good thing. Measured service is better than estimated service. And so we're moving to either direct metered or sub-metered model in the provision of electricity. And that's why we are looking to drop apportionment of electricity from the prior 504B.215. Here is in subdivision B is a reference to, again, the billing frequency being the same as the provider. And then there's disclosures. Subdivision C, 1 and 2, a landlord who apportions upon a tenant's request must provide a copy of the current actual natural gas or water and sewer utility bill from the provider that is being apportioned. So we have jumped again out of electricity into apportionment, which puts us necessarily into natural gas and water. So there's a bit of a shift there, but the point is there are disclosure requirements, and that relates to natural gas and water. And there is a provision in subdivision C2 for the historical billing for the previous 2 years, which is available also upon the tenant's request. A landlord also must include in the lease or in a separate writing notice of the tenant's rights under paragraph C, which is the right to the billing history and a copy of the bills. And again, this billing process must comply with the requirements of 216B 023 and 216B 022 and 024. 024 is a dispute resolution provision, which I will get into later. Okay, let's go to the next slide.
Gary, I'm actually going to interrupt you just for a second. Sorry. Wendy had a really quick question about the previous slide, the one on submetering of water, section D. She just wanted to clarify, is that only applies to submetering of water, correct? Since it's under that subdivision 4?
Yes, because
Okay.
that provision is repeated
Cool.
in other sections.
All right, perfect. Thank you for that clarification.
Okay. So natural gas apportionment, based on the previous billings, actual natural gas bills from the provider allocated to each unit based on the square footage. And that's the important part of natural gas. And that's a distinction between the apportionment of natural gas and water. The apportionment of water is based on the number of tenants in the unit relative to the number in the total building. And the apportionment of natural gas is based on the square footage of the unit relative to the square footage of the entire building. Now, subdivision 7D, I should have pointed this out as well. And subdivision C and D are new provisions in the apportionment space, which require expressly that the landlord deduct common usage areas and also landlord usage from the apportioned bill. So if you have a building that's got 20% space that is common area, that 20% should be deducted from the total building bill from the provider before the usage is apportioned among the tenants. So that's another provision that really the prior 215 was silent on, deduction for common areas, but has been made express in the new 216. Let's take a look at the next slide. Okay, so administrative billing charge is limited to $8 total for landlord or third-party billings. There is not allowed any administrative charge in excess of the $8. And this applies even if there are multiple apportioned or separately billed utilities. Late payment charge in subdivision 9 is limited to $5 per month. It's not compounded, and it's not to be repeated for an existing late payment. Now, subdivision 10, give me just a second here. Okay, subdivision 10, the disclosure in the lease of apportionment billing formula must include an attachment with the following notice. And that notice has to do with if you fall behind, you're entitled to a mutually agreed upon affordable payment plan. And this is similar to the consumer protection found in Minnesota statute 216B.098. And you can get a copy of the provider bill. And if there is no agreement as to a payment plan for the tenant to catch up, the tenant can file a complaint with the Consumer Affairs Office of the Minnesota Public Utilities Commission. So that is the following notice that subdivision 10 refers to. Could we see the next slide, please? A subdivision, now subdivision 11 doesn't appear here, but I think subdivision 11 is dealt with later in the slides, but let me just mention, subdivision 11 has to do with verification of apportioned bills, and an effort is being made to detail exactly what information needs to be provided in apportioned bills so that a tenant can calculate how their bill was arrived at and verify that it's accurate. This is something that has to be dealt with in the future, and the statute gives stakeholders until July 1st of 2025 to come up with a verification methodology that will provide more requirements for detail in apportioned bills so that tenants can calculate the way their bill was determined from essentially the face of the bill itself. Now, subdivision 12 is a protection of service provision. Disconnection for a failure to pay a utility service charge is prohibited. This mirrors 504B.221, but it's stated again here to make it clear that in the delivery of utility service, and I would say particularly in this context, in the sub-metering of electricity, disconnection by a landlord or a third-party biller is prohibited. Right, and so subdivision B also gets at some of the bookkeeping that attends or accompanies outside billing for utilities. If a tenant makes a payment to the landlord and that payment is designated as rent, that payment must be applied to rent. In the past, there have been some cases where a tenant makes a payment. The question has been raised as to whether the landlord can consider this payment of utilities, even though to apply some of the payment to utilities might result in a rent shortage, and actually then rebill the tenant for rent, claiming that the rent is short as some of the payment has been applied to utilities. This provision makes clear that that is not allowed, that once a payment is made that's designated as rent, where there is an outside utility billing process in place, it has to be applied to rent. Subdivision C is breach of lease claim, and it has to do with the threshold requirement before a breach of lease claim for failure to make utility payments can be brought. And the reference is made there in subdivision D, to a failure to make 2 consecutive payments. Any eviction action may not be filed, and anyone that's already been filed must be stayed for a failure to pay gas or electricity during the cold weather period, or for the failure to pay electricity charges during a heat emergency as defined by the National Weather Service, or if the tenant notifies the landlord that there is a medical emergency that will result from a shutoff. So this is a service protection provision, and also a application of payments provision that requires treatment of treatment of tenant payments and protection of tenant service where there is outside utility billing and, for example, where the tenant might have fallen behind. Let's move to the next slide if we could. Okay, this is the situation where the landlord is the payer of a shared meter building, and the utility provider issues a notice of disconnection because the landlord has failed to pay on the master meter. A tenant or group of tenants can essentially pay and deduct after giving notice to the landlord that that's their intent to do. And what that means, pay and deduct, means pay the last service period and then deduct that from the next rental payment after giving the landlord notice that that is what their intention is. There Right. This basically mirrors Section 504B 215 and includes that the tenant need only pay current charges, not the arrears incurred by the landlord, but protecting service requires only the payment of current charges. Let's move to the next slide. Again, this is a carve out. The protections under this section do not extend to problem circumstances or situations caused by the willful, malicious, or negligent conduct of the tenant or a person under the tenant's direction or control, cannot be waived or modified, and are in addition to other rights. Subdivision 15 mirrors the current requirement that by September 30th of each year, in an apportioned billing situation or billing separate from rent, must inform tenants of the availability of energy assistance or the LIHEAP program, Low Income Home Energy Assistance Program, and provide the tenant with information necessary to access that program. Subdivision 16 just makes it clear that violation of subdivisions 2 to 12 is a violation of the covenants under 504B.161, and it's also a violation of 504B.221, which again is carried over from 504B.215. Subdivision 17 is just a recitation or sort of stating it expressly that the Attorney General has authority under Section 8.31 to investigate and prosecute violations of this section. This is, again, an attempt to basically carry forward all of those protections in 504B.215 and add additional disclosure and disconnect protections, particularly in the case of sub-metering and apportionment. And Julia will talk a little bit more about the specifics of 216B, 022, 02, and 023. Thank you.
Thanks, Gary. And I would just kind of reiterate for 504B.216, clarifying that that is replacing what is now going to be repealed as of January 1st, 504B.215, the prior apportionment statute. But there was a question in the chat about the applicability of what would apply for leases that are month to month after January 1st. Gary, do you want to weigh in on that? If a tenant has a month-to-month lease, if they don't renew, what happens to their lease in terms of what statute applies?
Well, you know, there are perhaps other housing attorneys and perhaps you as well who know more about this than I do. My understanding is that when you have a month-to-month lease, legally, the lease is considered as renewing with each month's payment. And so my opinion would be that after that payment for the month of January, that would essentially be a new lease beginning February 1st, and that would be the end of the grandfather period. But there are other housing attorneys that maybe know more about that. But my understanding is that a month-to-month is literally a renewal with each monthly payment. And so that would be treated as a renewal after the first month under the statute.
That's my understanding as well. So if someone is on a term lease that's ending and they're just automatically rolling into a month-to-month tenancy, effectively every month-to-month term is a new lease, a new agreement by the landlord and tenant that they will be continuing the lease. And so at that point, 504B216, the new apportionment laws will apply. And then if you could just scroll back, Rachel, I wanted to make sure everyone, let's see, subdivision 6.
Any particular slide you want me to grab?
I don't know what number it is, but back to subdivision 6.
Oh, sure. Sorry, everyone, bear with me as we scroll quickly.
Thank you. Yep, so these are the two formulas people should just remember because these weren't in place before. Previously, the law said apportionment must be equitable, which wasn't very clear. Like it could be a bunch of different things, but now the law is prescribing a formula. So for gas, the apportionment should be square footage of the tenant's unit over the square footage of all rentable units in the building. And then one more slide forward. For water, number of tenants in the lease over the number of total building occupancy. So that's the formula that landlords should be applying for apportionment. And then apportionment of electricity is prohibited after January 1st for leases effective after that date. So those are kind of the main takeaways I would say on apportionment. I just wanted to summarize that before we move on to the next section.
Perfect. Thank you. I'll again take us on a quick ride up to this.
Okay, so next we're going to talk about new rules in a separate part of Minnesota statutes. Normally landlord tenant attorneys are looking at 504B, but 216B is a portion of Minnesota statutes that governs utilities and utility providers. But now there are some laws in this section that regulate the landlord tenant utility relationship. So you can move on to the next slide. So in subdivision, in 216B 022 is where it regulates sub-metering and shared metered residential buildings. It establishes that landlords who install sub-meters to measure utility service in a tenant's unit are now going to be subject to the Public Utility Commission's authority. It also requires that sub-meters installed after January 1st meet national standards for accuracy, specifically the American National Standards Institute, and that all sub-meters, regardless of when they were installed, accurately measure a tenant's utility service. So this is something to just kind of put some regulation around the installation of sub-meters because up until now, there had been no laws governing landlords who choose to use this practice to measure tenant utility usage. Next slide. So this is a lot of text here, but I'm going to just jump down to the bullet point summaries. Essentially, what's being provided in subdivision 4 is rules to remedy inaccurate submeters. So if a tenant believes that their submeter is inaccurately measuring their actual usage, they have to give notice to the landlord of the problem. And if a problem is actually identified, like the landlord determines that the meter was incorrect, the landlord must provide a refund if the tenant was overcharged. If the tenant was undercharged and the tenant actually owes the landlord some additional money, they can go back in time to try to recoup that money, but only as far back as the last 6 months. And then subdivision 5 prohibits charging administrative fees for submetering. And importantly, the cost of installing submeters cannot be put onto tenants' ledgers as an administrative or capital improvement. Instead, that's something that the landlord needs to pay for upfront. And then kind of along the same lines of making sure utility consumers are protected the same, whether they're sub-metered, portioned, or directly metered, 216B 023 has some additional consumer protections for renters. So the first one is that landlords who submeter must bill based on actual charges and not estimates. So that's the whole point of a submeter, is to figure out what was the actual usage in the tenant's unit. And so because the submeters are in place, a landlord shouldn't be billing based on estimates. And then this provision establishes how often and what should be, what information should be provided in the submeter bills to tenants. So if you look at that long list, number 1 through 8 under subdivision Part C there. This is the information landlords need to provide on their utility service bills for submetering. So this gives tenants the information they would need to determine if they are being undercharged or if it's accurate. And practically speaking, it also is information that landlord tenant attorneys can look at when they're trying to determine this issue. So even if a tenant receives the bill and doesn't really know what to make sense of it, if they call Homeline or call legal aid to try to figure out whether their bill is accurate, they can work with us and we can help with that more information than had previously been available. So this portion of the consumer protection statutes essentially reiterates the submetering rules and apportionment rules that we talked about previously in 504B 216 and 216B 022. So kind of these cross references just confirm that these protections apply and adds those laws here within the utility regulation section. And then finally, it reiterates the protections on a limit to administrative fees. So administrative fees, as we talked about, are limited to $8, and that's referenced in 504B 216. It also describes what should take place for billing errors. So similar to what I talked about for an inaccurate meter, if there's a billing error that results in an overcharge, the landlord needs to promptly refund the difference to the tenant. If there's an undercharge, the landlord can bill the tenant for the difference for a period going back not further than 6 months. So kind of mirroring those same rules in the case of either billing errors or inaccurate readings. And then finally, the late payment charges, there's a cross-reference to the rules in 504B 216, limiting late payment charges as outlined in those sections. Let me see if I'll save this question for our Q&A section, and I'll let Gary go forward. We're wrapping up the content here.
Okay, thank you, Julia. I just want to mention that building code reference that I made earlier, which does kind of reflect the state of Minnesota's policy with regard to measured utility service where possible, is 326B as in boy, dot 106, subdivision 12. And it's kind of obscure, but that's where it's located. And it states that buildings, multi-dwelling buildings constructed after around 1980, don't quote me on that, have to be wired for individually measured utility service to the dwelling units. Now,
Gary, can you give me that statute one more time and I will put it in the chat for everyone to reference later?
Yeah, and I was looking among my materials. I really like to have the writing in front of me,
yeah,
and I can't, but it's 326B as in boy,
mm-hmm.
0.106.
Perfect. Okay.
Subdivision 12. Somebody might want to look that up and check me on that.
Yep, I got you.
Yeah, because if I've got that wrong, I'll need to correct it before we're done here. But that's where I believe the building code makes that statement about the policy for separately metered multi-dwelling units, at least in the case of electricity. So let's move on to 216B.024, which is dispute resolution. Now, 216B.024 is closely aligned with a law that was passed in the 2023 session, which was 216B.172, which is the judicial review provision for public PUC or Public Utilities Commission action or inaction with regard to individual consumer complaints. And that's the important thing to keep in mind. 216B.024 and I'm glad to see that I was right about that citation. Thank you. 216B024 and 504B, I'm sorry, 216B.024 and 216B.172 relate to individual consumer complaints and judicial review of those complaints in the district court. And in both cases, those complaints begin with the Consumer Affairs Office after the tenant has attempted to reach a resolution with either the utility provider or the billing entity, if not the utility provider. And I'll go into 172 just a little bit and then get back to 024. But 172 was a result of 216B17. And 216B17 is the formal complaint statute for the review of utility procedures, but requires significantly 50 consumers or a public utility complaining against a public utility or a governmental entity complaining about a public utility practice. So it basically, 216B.17 was never really structured to provide an avenue for review of individual consumer disputes. And that's where 172 and now 024 come in. So you can see under the 024 language here that the tenant must first attempt to resolve the dispute with the landlord. If the tenant disagrees with the landlord's proposed resolution, the landlord must notify the tenant of the tenant's right to file a complaint with the Consumer Affairs Office and provide the contact information for what I call the CAO, the Consumer Affairs Office. And then at that point, as you'll see in the last sentence of 216B.024, at that point, it becomes a 216B.172 process. And the referral or the reference, I'm sorry, in that last sentence to Minnesota Rule Part 7829.1600, that is simply a general, 1600 is a general reference to the way the commission handles informal complaints. And that's what is considered to be the legal status of the complaint to the CAO. It's an informal complaint. And at that point, the Consumer Affairs Office will consider the complaint. Let's go on to the next slide. Oh, well, let me look at 216B.172. Now, so again, this is new language up here, or a landlord. So you have to first attempt to resolve it either with the public utility or the landlord, which is to say the public utility or the other billing entity. I want to draw people's attention to the last paragraph of 216B.172. That this paragraph details what the process must be. So the CAO must notify the complainant of the resolution of the complaint, provide written notice of the complainant's right to appeal to the commission, and the steps the complainant may take to appeal the resolution. Upon request, the Consumer Affairs Office must provide to the complainant a written notice containing the substance of and basis for the resolution. I would recommend that if you're looking at an issue, particularly an issue of law that you think might be reviewed either by the commission or a district court, that you definitely request that information. And I would also suggest that actually while the complaint is pending at the CAO, you may want to make a request to the CAO to provide information regarding the submissions by the other side. Now, I'm not clear on what exactly the requirements of the commission are to disclose that information. You may have to make a formal data request, but I don't think that the information on each side's submissions during a Consumer Affairs Office complaint are necessarily disclosed. And so you may want to request that if you have a complaint about a point of law that you think might trigger a review. And this particular language refers to requesting the basis for the decision. And I'm suggesting you may actually want to go one step further than that if you think you might be seeking review. That's the interplay of 172 and 024, with a brief digression to 216B17 and why 172 was enacted. And at the district court, the process would be through the regular appellate process. Now, I want to see, I know what right. So the options that are available to the commission, once you appeal a determination by the CAO to the Public Utilities Commission, the commission has several options. It can determine the dispute. It can refer the dispute for an informal proceeding, or it can initiate a contested case proceeding under Chapter 14. I just want to make this point about this process. If a dispute that the CAO has addressed is then appealed to the commission, and it is referred to a contested case proceeding under Chapter 14, then the procedure is different. Then you're into the administrative procedure, which results in a further judicial review at the Court of Appeals pursuant to a petition for a writ of certiorari. So that's a possibility even under 172. You may find yourself back in the certiorari process if the commission refers the matter to a contested case proceeding. If the commission doesn't act, refers it to an informal proceeding, or determines the complaint, and the complainant is not satisfied with that, the complainant under subdivision 4 can seek judicial review in the district court. And 216B27 is a rehearing provision, and a request for rehearing is a condition precedent in some appellate proceedings regarding the Public Utilities Commission. And this language makes clear that notwithstanding 216B27, you can go straight to the district court if you are in 172. If you have not, as it says in the last sentence, if you've not been referred to a contested case proceeding, which would take you out of 172 and put you into the Administrative Procedure Act, which is a writ of certiorari to the Court of Appeals. And then subdivision 5 is a protection of service during the pendency of a dispute. And payment agreement provisions of 216B098 apply. And I haven't mentioned this before, but posting, there's limitation on posting. You can either post the full amount in escrow, but if you qualify for public assistance, if you're informal pauperous eligible, or you're being represented by a legal aid service, there can be no posting. And similarly, if the household income is at or below 50% of the median, no posting. So we've tried to do a number of things here. We've tried to provide a quick process that improves judicial review access as it had previously existed under 216B.17. We've tried to protect service during the pendency of an appeal, and we've tried to limit the posting requirement. And that's how 216B.024 and 216B.172 kind of combine in this regard. That's a lot, but I hope that makes sense to people. So could we see the next slide?
I can
Okay.
jump back to that one and just add one comment. Um, kind of as I summarized at the bottom there, this is an existing procedure for appeal and judicial review. These laws aren't new. What's new is the application. So renters who had their bills directly administered by Excel or Centerpoint would have had this same judicial review process. But now that process is being applied to landlords who bill for utilities. So I just wanted to clarify that aspect, that this part per se isn't all new, but it's the application that's new. So
Thank you, Julia. And Julia backed me up too on 285 because there's a fair amount in here and there's not a lot of text, although it's pretty dense. So this is a state of eviction. So now we're moving to 504B 285. And this is a provision that provides for a stay of an eviction action if you have a complaint in subdivision 1 there, subdivision 4B sub 1. If you have a complaint pending under 216B 024, the eviction action must be stayed. Again, this is an eviction based upon a failure to pay for utility service in a shared meter building. I mean, that's up at the top, but let me not ignore that. So if you've got that kind of an eviction and there's a complaint pending under 024, then the court must stay the eviction action until the commission has made a final determination. And here again, no requirement by the defendant to post any amount of money into court or post a bond in order to pursue to conclusion the complaint under 024 and not be evicted for a similar issue while that complaint is pending. Then sub, so to speak, two, if you've not filed a complaint, involving natural gas or electric with the PUC under 024, but the tenant meets the indigency or the lower income requirements for a court waiver under 56301, again, the court should not require the tenant to post any amount in order to proceed. I just want to say something briefly about that. So there's been some confusion in housing law about whether raising utility issues either as an affirmative defense or as a counterclaim in an eviction action implicates Fritz versus Worthen, and which is a case about repairs and basically holds that if the tenant raises repairs as an affirmative defense to a non-payment eviction, the court can require the tenant to post a certain amount, typically the rental payments, with the court in order to pursue that repairs-based affirmative defense under Fritz. This is an attempt to separate utility-based disputes from the Fritz analysis and to basically put a brake, B-R-A-K-E, on any tendency to force a tenant to have to make a posting in connection with the utility-based defense. So that's what this is about, apart from all of the specific language we're looking at here. And then under sub 3, if the tenant doesn't qualify either financially or being represented by a legal aid service or other nonprofit agency, then the court can require a reasonable posting, but for prospective charges only. Subdivision 4C at the very bottom is just what I just said in statutory language. It is basically, look, if you've got a utility-based defense, this is not like a repair action where the court should be looking at some sort of posting as a condition to raising a utility-based affirmative defense, or even as a counterclaim. And that's so those are sort of the dual or even triple protections that is attempted to be incorporated in 504B.285. Let's see the next one. Yeah, 098. This is the new penalty provision. Let's see the next one. So this is commission authority to assess a fine, a penalty in subdivision B in a shared meter residential building for violations of 216B 022, 023, or 024 of not less than 100 and not more than 1,000 for each violation. This is just an extension of the commission's jurisdiction and incorporating and adding also a penalty provision to aid in the enforcement of 022, 023, and 024. This is, and we're trying to get near the end. Let's see the next slide real quick. I'm not going to say too much about this other than to say, just make a general comment about the history here. So, this stuff gets really involved. And as you can tell, even with the new statute, and I was involved in the drafting of the statute, it's tough to keep all of these principles straight. But this is a very complicated area. Utility billing, as we move into solar gardens and in Minnesota, we start to incorporate clean energy and other forms of alternative energy. The utility billing space is becoming even more complicated. And as we have third parties and perhaps landlords entering this space, this is a difficult and complicated space. There's a reason why we have public utilities and public service commissions and these entire regulatory and statutory structures around service requirements and billing requirements and undercharge provisions and estimated billing provisions and on and on and on. And I just want to say, this emanates, of course, from the old railroad and warehouse commissions that existed or became existent back in the 1800s into the early 1900s. And they evolved for a reason. And that is that this is a complicated area. And as we get into solar gardens in Minnesota and solar energy and perhaps wind energy, this is going to become an even more complicated area. And I just want to sort of say, I think it's easy to take for granted what the regulators do and what the commission does in this space until you sort of have to confront it on your own and you realize either as an advocate or as a tenant or as a biller or as a landlord, just how complicated this can be. So I just want to say this is not simple, and I hope that this has been helpful.
And that is an excellent segue, Gary, into our question time. We've got about 20 minutes left of our scheduled time. So I want to say, first of all, thank you both so much for diving into, as you said, this complicated topic. Hopefully, this will also help clarify a bunch of things for folks. We had a few pre-submitted questions that I want to get through. That's the perk of submitting your questions ahead of time, is that I ask them first, typically. So we'll get through those quick, and then we've got a couple of questions in the Q&A. So if you have questions as well that have come up during this that you want answered, feel free to put those in the Q&A, and we'll do our best to get to those questions. All right, so we had a couple of different ones kind of along these lines from Jordan, who's a tenant. They're talking about shared meters. Does a shared meter include payments for bundled utilities when you get like all of your utilities kind of bundled into one payment per month? I know some landlords do that. So Gary or Julia, can you kind of talk about that?
So if what we're talking about, and Julia can chime in too, of course, I'll just say, if what we're talking about is flat rate utility charge separate from rent, that's an apportionment that really isn't allowed. And so that really should not be happening. But if you've got, it's the shared meter is about exactly, and I mean this literally, it's about a shared meter. So if you have a situation where the individual units utility usage is not separately measured apart from other common areas or other units, then you've got a shared meter. And if you've got a shared meter and the landlord wants to bill separately for utilities, that should be done pursuant to the apportionment. It shouldn't be done as a flat rate.
Gotcha. All right. Um, Moving on to Roxanne also asked just a quick question of, does this law apply to all apartment buildings in Minnesota? Absolutely. Are there any exceptions though to this, like owner occupied apartments or anything like that?
No,
Okay,
I don't know.
perfect.
No.
All right. Um, so Ethan was talking about what the term base rate means. That's not something that is defined in the new definitions under 216. They're asking, does it refer to paying one standard cost? Because their utility costs change from month to month, it sounds like.
So that's a good question, and it's a little bit beyond I'm not a rate expert. I
Sure.
understand that there's a base rate, which is what the commission approves, that is the standard residential rate. But I've come to understand, as this questioner points out, that the rate can vary with certain additors or certain conditions or circumstances. And to the best of my understanding, a base rate is just that basic residential rate that is approved by the commission without any additors or without any adjustments.
Okay. Brianna is, I believe, a landlord, but they're wondering how and what of all of this topic applies to reservations.
And that again is a little bit beyond what I happen to know. But my guess is that if you're talking about native land and the native land and the utility practices on that native land are not under the jurisdiction of the state of Minnesota or subject to the application and enforcement of Minnesota statute or Minnesota rule, I would expect this does not apply.
Yeah, consistently. Yeah. Catherine is a tenant. And so just to kind of clarify, we talked about this briefly, but Catherine's talking about shared house meters in common areas. Under the new laws, that wouldn't be allowed to be charged. Common area costs would not be allowed to be charged back to tenants as part of this shared meter utility billing, correct?
That's correct. If she's talking about a roommate situation, they're not actually separate units.
Mm-hmm.
That's different. But
Sure.
right, but if she's talking about separate units, correct.
Okay. And a third party utility biller would still be allowed under the new statutes, correct? Yep.
Yes.
All right. All right. Margaret is a service provider, and they were just talking about getting transparency about the actual cost billed to the tenant. You talked a little bit about how the tenant can get more information about getting that. So can you just briefly, like one more time, kind of hit the high level points of like how a tenant would ask for that actual utility costs so that they could do their calculations?
So the tenant can ask for the current bills and bills going back 2 years. And in terms of what is going to appear on the bill, because the object here is to get the four corners of the bill. So there's 2 points here. One is what the tenant can request, which are the actual bills currently, as well as the billing history.
Mm-hmm.
That's the 1 point. Second point is we want to get verification on the face of the bill so the tenant in an apportioned billing situation can calculate from the bill the way their amount was determined. that's where the usage, non-usage, that's where sort of this nomenclature starts to matter. And so that particular aspect is actually punted, if I could say, use that term, until July 1st of 2025 for landlords and landlord associations and tenant advocacy organizations to get together and come up with a methodology for, as much as possible, making the bill in an apportioned billing situation verifiable from the four corners of the bill.
Okay, perfect. Cared is a service provider. They asked the same kind of question as Catherine did about charges for common areas. So we'll go on. Linda is asking about, so does the statute cover the extra utilities landlords are charging in addition to the tenants like Excel or Centerpoint bill? So that's going to be like the water bill, or it sounds like maybe trash and sewer and such. So
the answer is yes. Deductions for common areas and common usage. If that's it, am I responding to the question here? Am I understanding the question correctly?
So the Linda service provider says, does the statute cover the extra utilities landlords are charging for in addition to the tenant's Excel and or Centerpoint bill?
Well,
And
that would be water, and the answer is yes.
yes, so that would be
yes.
And then last pre-submitted question from Ronald that this came in this morning, so you didn't get to see it ahead of time. Sorry, but I think you got this. Does the shared meter residential building rule affect public housing?
Yes.
There we go. All right, easy enough. I like the yes, no questions. They make life a little easier. We don't often get those. Okay, so now on to the questions that came in during the session. We do have about 10 minutes left, so we're doing great on time. So thank you all. So we'll just kind of go in order. Sherry is wondering, can a landlord require a tenant to pay for a direct meter and a sub-meter?
Well, no, you wouldn't have a direct meter and a sub-meter.
For the same utility, but what if like the electricity was a direct meter and like the water was a sub-meter or something like that?
Oh, I'm glad you clarified, Rachel. I wasn't following. Yes. The direct meter is going to be paid to the utility provider. In your example, the sub-metered water is going to be paid to the landlord.
Yeah. So Sherry, if I got that wrong, where it's two separate utilities, they can be different, but if it's one utility, you can't have one bill.
Yeah, you wouldn't have. Yeah, you wouldn't.
Yeah. Perfect. Okay. Anonymous is wondering, are sub-meters installed by the utility providers? If so, is a sub-meter installed by a utility provider at the request of a landlord a sub-meter installed by a landlord? So there's kind of two questions there. The first being, are sub-meters installed by the utility providers?
So no, the answer is no, because what the utility provider installs is a direct meter. But if you're asking, does the utility provider step in to install what we would call a separate meter, whether you call it, I mean, it's not a sub meter, but let's say it's a separate meter. It does the utility provider, let's say in the case of electricity in Minnesota. So now the provider is Xcel Energy. So does Xcel Energy step in to provide a meter in a unit that has been apportioned previously, but now is going to be measured? The answer is yes. And if you go to Xcel Energy's tariffs, and it's tariff rate book 2, and it is section 4.1, use of service. In that tariff section, there's a statement by Xcel Energy that the company, as it calls itself, capital C, in its tariff, stands ready to provide individual metering under that building code section that I cited earlier, pursuant to 326B.106, subdivision 12, at the request of a landlord. So you can have Xcel Energy come in and provide direct metering, so to speak, after the fact. At the same time, the landlord could elect to install its own meter. Typically, sub-meters are owned by the landlord, because once the biller, billers can change. Landlord might change who the landlord's going to use as a biller. So typically, the sub-meter is purchased and installed by the landlord and is owned by the landlord, not the third-party biller. And so that's generally the way that works, and that can be done as well. So you could have it direct metered by the utility provider. You could have it sub-metered by the landlord. Typically the landlord, nothing preventing the third-party biller though, from
Sure.
being the sub-meter provider also.
Okay. All right. This next question I think has some good layering to it. So I'll try and be clear about what is being asked. So if a resident fails to put a sub-metered utility bill in their name and the landlord rebills the tenant for the utility bill, what is your position on the additional fees, if any, that can be charged back to the tenant as a result of their failure to put the utility bill in their name? So there's a sub-metered bill and the tenant is supposed to put it in their name, but they fail to do so.
So a sub-metered bill would not be in the tenant's name because, again, only a direct metered bill. So again, we're getting into the nomenclature. So it's a direct metered bill that is where the service to the individual unit is measured by the property of the regulated provider. Xcel Energy owns that direct meter. Now you're a customer of Xcel Energy. Now you'll put the account in your name. If it's a sub-meter, the account is actually in the landlord's name. And you would be paying pursuant to the measured service under the sub-meter to the landlord. If you're talking about putting account in your name and you fail to do it, then you're talking about a direct metered account. And if that happens, landlord pays it and rebills the tenant for reimbursement. In that circumstance, the tenant or the landlord should not be adding fees beyond the administrative fee, the $8 administrative fee. And this gets to another provision in Xcel's tariff. Again, the use of service 4.1 in rate book 2, basically prohibiting resale of electricity. At some point, when you start talking about add-on fees, recoupment of capital expenditures, and that sort of concept, either to a third-party biller or to a landlord, at some point you've crossed the line into the resale space, and resale is not allowed. So yes, there could be a small fee if necessary to reimburse the landlord.
Okay. I got just a couple more questions. I think we've got just 5 minutes left, so we'll barrel on. How is district heating cooling billed back? I think that's some terminology that I don't quite understand, but I'm hoping you do.
Say that again. Could you say that
It
again?
says, how is district heating cooling billed back? I don't know what district heating cooling is, so sorry, I cannot elaborate more. Do you have a sense of what that is, Gary?
I I don't. It sounds like
Okay,
a reimbursement.
sure.
And
So,
I should clarify earlier, if you're reimbursing the landlord, there might be a late fee. That's really what I'm thinking. Not
oh,
so
okay,
much an administrative fee, but there might be a late fee. So
sure.
anyway, but
Sorry. Yep.
I'm not sure with a
Okay.
district. I don't know what
So,
that's a reference to.
Anonymous, if you're
Sorry.
still here, if you want to give us a little bit of clarification in the Q&A, that'd be great. Otherwise, sorry, I don't necessarily know exactly how to answer the question. Adam has a straightforward question. They're wondering for mobile home parks, do they just still look to 327C.04 exclusively, or is how much of this new stuff will apply to mobile home parks?
So I don't know. I mean this is a matter that's currently being litigated, is
Okay.
whether 327C abrogates the apportioned billing provisions with regard to mobile home parks, or whether mobile home parks are as well subject to the apportion billing and sub-metering provisions. And I don't think we have a clear answer to that yet.
Okay. All right. So then,
I think, let me say this. I think that historically, people who have more experience with manufactured home parks than I do, I think that historically it has generally been assumed that manufactured home parks are in their own legal universe, and 327 is kind of their universe, and 504B is a different universe. I think that's been the presumption, but I think the actual answer to that question is currently up for decision.
yeah, there's definitely some crossover about how things apply. So, so Adam, as with all good legal answers to be determined. Um, all right, so Anonymous is wondering, will the prohibition on common area utility bill backs be effective for everyone January 1st, regardless of the lease end date, or will common area bill backs be permitted until the lease end date?
Well, that raises the question about the quote unquote silence in 504B.215, because many landlords, to their credit, have assumed that, well, I wouldn't be billing for the common area, and they've been deducting it. The statute is silent. So the answer to your question actually turns on when does 216 apply in your individual circumstance. And if 216 doesn't apply for some period of time, then the question is, does 215 just sort of commonsensically require deduction of the common areas? Now, I will say this about that. One of the best definitions of a shared meter is in Xcel Energy's tariff. Xcel Energy's tariff says if a utility meter measures service inside the tenant's unit and outside the tenant's unit, that's a shared meter. Now, what that says to me is, under the common law in the state of Minnesota, we don't expect tenants to pay for service outside their unit. And so I would submit that even notwithstanding the silence of 215 on this point, it's generally contemplated in Minnesota that a tenant is not going to pay for service outside their unit, and that a deduction would apply whether you're under 215 or 216.
Okay. Thank you for that. All right, we are coming up on 3 o'clock. We only have a couple more questions. Would you two be able to stay on for another couple minutes just to finish these up?
Sure, I can.
All right, perfect. Because I think we've got an interesting, a couple of these things are coming through on this district heating cooling. So I just want to make sure, we're going to get back to that in just a second, but I want to reply back. Sherry had been the one that was asking about the direct and sub-metered billing earlier, and she wanted to clarify if we have that they have clients that are paying a direct provider and a third party from the city for the same utility, such as electric. And is that allowed?
Both on the same utility, both on the electric?
That's what it seems to be. So
I don't think I don't understand. If you're direct metered by the provider, that would be your sole payment. I don't understand what the city would be billing for in addition to what the direct provider is billing for. What's left? In other words, what's left for the city to bill for?
yeah, so that would be a very specific question. I wonder if it's like that's a great question, Sherry, that we might need to take offline to get some more dig some more
Yeah,
research into.
yeah. Someone could
But
perhaps
good question.
forward me an email,
Yeah.
or something, and at least if you want my opinion on it. Yeah.
I mean, your opinion is pretty good.
Thank you for that. Thank you.
All right. So finally, the district heating cooling bill back. So anonymous, I'm assuming these are not all the same anonymous person, but St. Paul has district energy, which appears to be a utility provider that provides heated water and cool water to the downtown St. Paul and adjacent West Side neighborhood areas. So again, this is something that seems fairly specific to this area, but um,
So, and they're okay. So they're a provider and they're a provider of both hot and cold water, maybe for heating purposes as well as usage,
Mm-hmm.
within a certain area in the St. Paul area. Um, and the question is, could you repeat the question, Rachel, in that
How is
setting?
district heating cooling billed back?
Well, okay, build back. I mean, I'm assuming that the building receives a bill from district cooling and heating, and then the building maybe apportions that bill. I don't know exactly what the billing mechanism is in that
Yeah.
setting.
So it's
If it's
unclear
if it's
whether it's a
apportionment, it would
mhm.
have to follow the apportionment. Um, I, I mean, I don't, I'm assuming they're not submetered in individual units, so there wouldn't be measured service. So there wouldn't be a direct bill for measured usage. There would be some kind of apportionment where the tenant would pay pursuant to the apportionment
Mhm.
provisions, a certain amount pursuant to a formula to the landlord. I'm just assuming that each site is provided the water service that we're talking about here, and then there's a monthly bill. I mean, that's my assumption, is that it's basically an apportionment
Yeah.
question.
And I guess the other question would be, since it's heating, right? But it's also a water heat. So is it billed at the water rate where it's per person divided by the occupancy, or is it at a different, like um what's the formula?
Well, I mean, the typical energy source, of course, for heating is gas.
Mm-hmm.
So are we talking about a combined gas and water service? I'm not really clear, but if it's gas, it wouldn't be billed as a water bill. It would be billed as a gas bill. I mean, typically, and
But
and it right. I mean, I don't know. It
so,
wouldn't.
but if
It
it's
would. Go
mhm.
ahead. Go ahead.
Well, think about like radiators and things. If it's hot water going being
It's going to
put,
be billed
what?
as a gas bill,
Okay.
right? It's going to be billed as a gas bill for the
Okay.
heating, that is, the gas that's consumed in the heating function, and that's going to come to the individual building, I would expect, or the individual site, and then it's going to be apportioned to individual tenants, or it's going to be folded into the rent and just included as part of the rent,
Sure.
um, total. You know, I mean, that's my guess.
Okay.
I'm sorry, I'm not familiar with that arrangement, so I can't really speak more specifically to it.
Okay.
Yeah, I
So I
can't,
think
I,
mhm.
I think it's an anonymous attendee, but if you want to connect with us, I think Gary and I would like to learn more about it. Because if this is something that's kind of a gap in the legislation, we would want to help clarify this session possibly.
Absolutely. And this does seem to be, I mean, obviously it's impacting many people who live in this area, but it's also a fairly niche, thing for this particular utility provider. So um, that's a good question. Anonymous was also asking about CLE credits. We will email the code once we get it. We still have to apply for it.
So I don't,
Um,
let me
mhm.
just say one last thing on that point. As I was going all the way back, right? If you're talking a portion service or estimated service, there should not be a flat fee. There should be some methodology for an apportionment. Let me just say that. In terms of the way something is billed back, it really shouldn't be a flat fee if it's estimated service. I just want to say that.
Perfect. Okay, great. I think these are all been great questions. Thank you all so much. Um, so very last under the wire question here. I see you, Anonymous. How is the $8 admin fee decided? Like why that number? Why not $5?
That's a good question. And the group had a lot of back and forth over administrative fees generally. And $8 was a compromise based on at the time, the existing administrative fee among regulateds. That's where that $8 came from, is it's comparable to what the regulateds charge as a set administrative fee. So
Okay,
that's where it came from.
perfect.
And I think for context, we participated with landlord lobbyists in kind of negotiating what would be a reasonable compromise. So it was coming from both, landlord side, tenant side advocates working together.
Yeah, I haven't made that point enough. Thank you, Julia. This is a large group, and it included landlord stakeholders and utility billing stakeholders and state agencies, as well as tenant advocates. And that's true throughout this process.
Absolutely. All right. Well, again, thank you all so much. We are done with questions, and I was lots of really great information. So again, thank you all. Thank you all for joining us today. The recording will be up on Home Loan's website shortly, within the next day or so, along with the PDF version of these slides. Thank you again, and I hope you all have a great rest of your day now.
Thank you.
Thank you.
Bye.
Bye now. Bye-bye.